Okay. Ladies and gentlemen, boys and girls, welcome to yet another episode of Wick TV. Now, we got some stuff going on today, okay? This isn't the whole panel. The panel's not till 6:15, but my broskies here decided to show up a little early while I do the little pre-talk, and they're welcome to stay and chat, and if they got thoughts and opinions and things like that, they can feel free to speak them. But so if you're looking for the panel, that's in 15 minutes, so you don't got long to wait. And that's going to be on the Maryland SCOTUS decision regarding LGBT books being taught in English class. And this decision, 6-3, I believe it was, saying that the school district had to provide an opt-out for parents in order to keep teaching those things. But we'll get to that when we get to that. First, there's a couple things that happened this weekend today that we want to talk about. But first of all, Stock, nice to see you. Welcome to the show. Nair says, Wick, people are saying you were prepping the conservatives against the libs behind closed doors. Sounds pretty gay. Was I prepping you guys? Or was I engaged in?
Absolutely. Wick is
He gave us all the answers.
Yeah, he's a secret conservative, ultra dark MAGA. He's he's been waiting till today to unleash his conservative agenda. This is it. This is the crescendo.
He picked today of all days.
The
worst day.
The funny thing is that there's a certain segment of the internet that will believe you, that they will uncritically believe exactly what you just said, that I, because I'm not here calling you slurs, am secretly on your side for everything. And I've been feeding you information behind the scenes or something. I don't know, but we'll see. Concluding postscript, nice to see you. What would the liberal argument even be in this case? Well, we're going to find out today. Okay, we got two also lawyers coming back. Mike, you guys liked Mike when he was here. Mike will be back, and we're going to have, for the first time on my show, Mr. Kafka Esquire, who is also, as I understand, a lawyer. Basically, honestly, what I wanted to do today was make lawyers fight for our amusement, because it's funny, and I enjoy doing things like that. So welcome. Zero Fox, nice to see you. Jovan says they admitted it. Oh, that's true. Wick just said, I've been feeding you information behind the scenes. He just uttered those words. Also true. Right? Again, there's a certain type of person who will believe you. But before we get into that, there are two things I wanted to discuss today. How about those Epstein files, gang? You guys enjoying the fact that they just got... Wait a minute, they didn't get released at all. The government says, Trump's admin, basically, Trump's FBI, Trump's Department of Justice, just said that there is no Epstein client list. He actually killed himself. He wasn't murdered. And that he wasn't even blackmailing anyone to cover it up. There was no blackmail involved. This is a remarkably different tune than what they've been singing in the days previous. I like, you guys are more conservative than I am, right? What are your thoughts on this? I'm just really curious while you're here.
The only thing that's remotely credible is the literal phrase, there is no client list, because probably that information is amongst multiple documents and multiple devices. It's not
no one thinks it was like a literal like scroll that he had that he was writing the names in. No one believes that. We're talking about
exactly. I think that is, if taken hyper literally, is probably true, but the rest of it, I think at this point, you're not wearing a tinfoil hat if you say that it is likely that there are people who are movers and shakers, probably on both sides of the aisle, in positions of power across multiple administrations who are on this list, and that everyone just in a position to make decisions thinks it's better that it doesn't come out, because that seems, the probability of that seems overwhelmingly high at this point. At least to me.
I'm just, first of all, Kafka, nice to see you. Is that what you like to say? Here's your name. I know the panel's not for 10 minutes. We're just doing some pre-stuff. You can say if you like. Right. But Um,
No, I'm hopping in. I'm just setting up on my end, so I'll probably be quiet for most of this.
all good, all good. Let's see what I don't know if you guys can see this, right? Maybe I'll share my screen. Hold on. Give me a second, and let's see what our friend JD Vance back in. Let's make it big so you can see. Right? What did Mr. Vice President here have to say about it in let's see, December 30th, 2021. He says, "What possible interest?" This is a reply to a Jack Poso tweet, Jack Posobiec, who says, in the interest of context, "Are you paying attention yet? The DOJ and Ghislaine Maxwell's lawyers have made a deal that her little black book of contacts will never be made public." And he links to the story about it and things like that. And then JD Vance quote tweets this and says, "What possible interest would the U.S. government have in keeping Epstein clients secret?" Oh, I guess it's a valid question. It's a valid question. I, too, would like to know the answer. And who better to answer than the literal Vice President of the United States? So, J.D. Vance, if you ever are listening, which is non-zero possibility, right? Sometimes weirdly big people tune into my show. Yeah, what interest do you have in covering this up? I'm just really curious. I don't know.
The one thing I'll say, I'm trying to figure out how I can say this without, there are specifics I can't say, but
Okay.
in a number of my representations that have nothing to do with Epstein,
Okay.
you'll find, or you think have nothing to do with Epstein, you'll find some bigwig, some very rich individual, some powerful man, and there's some tangential Epstein issue that becomes something that gets litigated because he knew everybody. He was friends with everybody. That does not mean, by the way, that there was necessarily anything illicit happening with that. But like,
Certainly.
he was in the business of being friends and friendly and an advisor to the powerful. So that's what he did. And he knew everybody. So, with that in mind, when this stuff happens, I think it just is worth remembering that this man was friends, was friendly, did advise a huge number of incredibly influential and powerful men. So for whatever that's worth, that certainly colors the way I view this information.
I understand that. I get it, right? In again, I think that people make too much a big to do. As you said, he knew everyone. So people who simply use the fact that, oh, Epstein talked to this person before, or they were at an event with Epstein as some gotcha, is stretching it a bit, right? It's really kind of stretching things. But we're talking about a Department of Justice, Pam Bondi, who said in response to being asked directly, "Hey, what are you going to be doing? When are we going to see the client list? When are we going to see the list of clients?" And in a direct response to that question said, "I have it on my desk and we're reviewing it now." The only thing the context of that is, and the only way I can understand it, is that she had something on her desk that showed a list of clients, whether that be a scroll, a little black book, whether that be the federal agents have combed through the evidence and put together a list, right? Something. And now they're saying that it doesn't even exist, and I'm just very skeptical of all this. But I will say this before we move on to the second thing I want to talk about before we get to the panel. I called this back in August of last year. I told you guys, if Kash Patel becomes, or if Trump gets elected and Kash Patel becomes FBI director, we are never seeing the client list. I called that shit. It's on the record. You can go back to my timeline. You can look at it. Okay, just another Wick W, but I wish I wasn't right in this case. This is just one of those things where I was like, I'd rather be wrong, but here we are.
Wait, can I ask you something real quick?
Yeah, go ahead.
Do you think that this might be a case of the shadow banning versus algorithm reduction kind of thing, where they're like, well, there's no list of clients, and they just define it away because there's actually a we have the flight logs or something along those lines, where they're just kind of like, oh, actually, that never existed because there never was an explicit. They might kind of just be playing word games with us right now. Do you think something like that's happening?
But to what? But then the question becomes, to what purpose are they playing these word games? It's obviously, even if that's true, and I agree. Like I said to Ryan earlier, I don't think they have like a literal scroll of names, right? I think it's more likely that it's been generated through detective work, where they go through the evidence and they put together a list of possible what are those people called? Witnesses? Not witnesses. Not clients. Well, clients, I guess, in this case works. That's more likely that's what we mean when we say the client list, right? That's what I mean, at least.
Like, even if it was government created, like if the government had created their own based off all of the evidence they have together, they should still release that list, right?
Absolutely.
Yeah.
I mean, so all right, can I give the maximum charity
if you must
version?
Yes,
for the record, I think I've already said I don't think
if anybody deserves it, it's Epstein.
But if you're going to give the maximum charity version, right, you would say they have information about who he was communicating with. They have information about who's going to the island. They have flight logs. They have all that. They don't know who's who in terms of, like, he knows everybody who's like a client for some illicit purpose and who is somebody who is, communicating with him for some other purpose. And they just aren't in a position to disaggregate the two. That's my maximum charity approach. Like I said, I don't think that's probably the case, but that would be, I think, the best good faith argument you could make for the other side.
Yeah, there is a world in which but why wouldn't they just say that in that case, saying, hey, this is an ongoing investigation. There are people we are looking into, and we don't want to tip them off. And so we're keeping this confidential for now until we get all our ducks in a row and we can actually bring prosecutions and actually get this done. That would be the easiest thing in the world to say. Why didn't they say it? And it just adds a lot of questions. Mike, nice to see you. Can you talk to make sure we can actually hear you?
Yeah, hello. Can you hear me okay?
Hi. I know we're a little early, right? But I wanted to go a little early just to talk about the Epstein client stuff because it was news, right? And we're here, right? So here we are. I guess, like, I'll talk about the joke stuff later at another time because we are all here, and gang, you all are here to see a debate, okay? And let's get to that. If everyone's ready, has everyone's got all their drinks, their waters, their bathroom breaks taken care of? Everything good?
Yep, all good.
Okay. And on that note, welcome to yet another episode of WIC TV, a cross-ideological space where we come together to talk about issues both political and cultural, from the silly to the serious. Today, ladies and gentlemen, we have a show for you. Recently, the Supreme Court of the United States of America came down with a decision regarding a case in Maryland between a school board who had recently added certain LGBT books to their curriculum, their English curriculum specifically, and a group of parents who were mad and angry at the school board because they didn't have the option to opt out their child from that curriculum, from that course, because again, they weren't being taught in health or whatever, it was being taught in English class. The Supreme Court, in a 6-3 decision, ruled that for the parents in this case and against the school board. But the question is this ruling wise? Is this a correct decision based on the interpretation of the laws? Or is this just a form of bigotry and activism? Gang, we've got a show for you today. We got some great guests to talk about it. So I'm going to give each of them a short introduction. So just introduce yourself, tell people who you are, what you do, why we should listen to you, and your initial thoughts on the case, and then we'll get into it. We're going to start with Mr. Kafka Esquire. Go ahead.
Hi, everybody. Before I start my introduction, I'm going to apologize. I'm on the back end of a minor cold, so I'm going to sound phlegmy, and I'll be muting myself every so often, probably to cough. But otherwise, I should be able to make it through this. So my name is Kafka Esquire. I'm an attorney who works primarily in federal civil litigation with a background in criminal appeals. In law school, I also studied some K-12 educational law, so this material isn't entirely foreign to me. I'm also a writer for the Pragmatic Papers, a newsletter focused on combating misinformation and voter apathy. While I don't give out personal information generally, I will share that I'm a father and a practicing Christian. I don't think these are a prerequisite to discuss the case, but I think some listeners might think so. To keep the rest of my introduction short, I'll just say that for now, my position is that the SCOTUS is incorrect in their decision.
Oh, I'm very curious to hear your reasoning, and we will get to it in the opening discussion. Let's give the mic to Mr. Lactoid. Go ahead.
Hi, I'm Lactoid. You can find me at Lactoid TV. I agree with the Supreme Court's majority decision here that the Maryland School Board decision to mandate literature that overtly lionizes LGBT behavior paired with instruction to encourage pushing children into supporting LGBT behavior without allowing parents to opt their children out violates the First Amendment as it regards religious expression. This is because the Supreme Court has long recognized that freedom of religious expression protects the right of parents to direct the religious upbringing of their children, that children, especially subject to authoritative adults, are uniquely coercible, and that LGBT behavior is antithetical to most religious convictions in the U.S.
Okay, thank you for being here, and we'll get into it as we go. Next up, second time on my channel, so he liked it enough to come back. Mr. Mike, go ahead, please.
Yeah, thanks for having me back. My name is Mike. I have been practicing law for about 7 years, mostly in patent litigation, technology transactions, so a very heavy background in intellectual property. And I'm licensed to practice law in New York and California. With respect to this opinion, like Kafka Esquire, I disagree with it. But on a more fundamental level, and I'm grateful that Ryan's here today because I wanted to talk to him about this, and Lactoid as well. But specifically about originalism, this is not an originalist opinion, and I think this opinion is one of many examples of the conservative justices of this court ruling, applying originalism when it suits them and ignoring originalism when it doesn't, and being as ideologically driven as really any other Supreme Court justice. And so I dispute the idea that this is the most neutral, principled, nonpartisan court, at least those 6 judges. So that's my main point. I also disagree with the opinion on the analysis, the sort of quote unquote standard non-originalist analysis. So I'm happy to discuss that as well.
We'll get into it. This will be a good one, gang. And finally, last but certainly not least, Mr. Ryan Mullally.
Hey, Wick, remember push to talk? I got it. Glad to be back. My name's Ryan Mullally. You can find me at Ryan C. Mullally on X. And hopefully, if I've mastered this new recording software that is easy for most, hard for me, maybe on YouTube at Natural Law. We'll see if there's a place I can put these videos. But in any case, I'm an attorney. I've litigated at the Supreme Court level. I clerked for a federal judge, so I have a good understanding of how these cases are developed and decided. And as pertinent here, I was a elementary school teacher for 7 years before I went to law school and a Teach for America alumni. So I have a pretty good understanding of how these issues play out in the classroom, and I'm a father, so have a bit of some skin in the game and how these things turn out. And I echo what Lactoid said. I didn't even really think this was a particularly difficult case, to be honest with you. I thought the outcome was relatively predictable and was in keeping with the court's case law in Yoder, which is essentially what determined this outcome.
Okay. Well, I mean, that's the standards in these things. That's where everyone has lying or not lying. That's where everyone falls. Okay, on whether they agree or they disagree. Let's get into the why. Kafka, I want to go to you first, and then we'll just have the open discussion. People can reply, interrupt, all that. You said that this is incorrect. Why? Can you elaborate?
Sure. I think that first and foremost, I think that Alito has a kind of a critical misreading of Yoder, in the sense that I think that he stops incredibly early into the analysis of it, and when applying it to these facts. Yoder is about a case regarding the Amish community in Wisconsin and how they were contesting a law in Wisconsin that required them to send their children to high school. In their view, in the Amish society, at the age of 14 is whenever young men and young women start learning more adult skills, become more integrated into the society of the Amish society. and going to a high school would remove them from that society and make them unable to participate in it. Now, it's important to note, Yoder isn't about those Amish children's religious rights. It's about the parents' right to direct their religious upbringing. And Lactoid is correct, and that is where we're going to be discussing this. But it wasn't simply that the religious upbringing was affected by them going to school or potentially disrupted, or that there was some kind of possible disagreement with the teaching material. It's that the Amish parents were required against their beliefs to send their children to a school and not raise them in their religious practices. It was not simply that the school had differing ideas, it's that the school separated them entirely from their Amish community, and it made it impossible for the Amish parents to properly raise their child per their religious beliefs. At no point does Alito actually show this connection between Yoder and Mahmoud B. Taylor. Instead, he refers to a psychological effect, a potential exposure to materials, all things that are well settled as not meeting a freedom of expression violation. It is inevitable that at schools, children will run into ideas that their parents would disagree with, and there's no right for a parent to come in and dictate if their child can see that or not. I think that Alito really just did not carry his burden and that first religious burden test, no pun intended, of showing that there was an actual imposition of the government between a parent and their child as far as religious education goes.
Thoughts?
I can push back against that. I don't see a huge difference here. It seems to me that it's simply a difference in scale as opposed to a difference in principle. So Yoder talked about how, hey, these Amish kids are going to a high school. This, they're being taught things. They're being kind of put into this culture, which is antithetical to Amish religious beliefs. I don't understand how this is all that different from saying, hey, parents can opt out kids from high school to avoid them being indoctrinated in these beliefs, and just taking that same principle and saying parents can opt children out of this specific lesson plan, which is antithetical to their religious beliefs, for the exact same justification. It seems to me, again, it's like just a difference in scale as opposed to a difference in principles. It's also not just about exposure. I think this is going to be like a difficult kind of way to parse this, but it's specifically about pushing a agenda. I mean, that is what, if you look at the books and you look at like the instruction that was given to the teachers, that is what the goal here is. It's about pushing a particular set of ideas that is antithetical to their religious beliefs, which again sounds exactly like what the arguments that the parents made in Yoder.
And just to piggyback off what Lactoid's saying, it's specifically about K to 5. And Yoder, and for those of you who aren't lawyers who haven't read the case, Yoder's the key case here. This is the case that the Supreme Court rested its analysis on. So we're going to be talking a lot about Yoder and whether they used it fairly or not. But Yoder is inherently a very fact-specific inquiry. It's not a bright line test. You have to look at the specific facts and the specific situation to see if there's a substantial burden that's been put on the parents' right to instruct their children in their religious faith. So here, when you're talking about kids who are K to 5, and you're talking about including texts that the Supreme Court, I think correctly said, are expressly normative. They are there to provide a worldview and to say that that worldview is correct. And you're explaining it to kids who are not at the age yet where they can hold two ideas in their head and say, well, the teacher says X, but I might disagree with the teacher. They are at the age where their teacher has inherent moral authority, like a parent's truth. Substantially. And then just to respond to something that Kafka said, there was a lot of back and forth in the case about coercion, but one of the things that can't be disputed is that sending your kids to school is non-optional. It is the law. You must send your kids to school. And the burden in this case was specifically that these parents felt that they had no choice but to take on tens, $20,000, $30,000 of additional cost to send their children to schools where they would at least be notified or have the right to have a say in these matters, which they were not going to have in public school. And when the government provides a service, it cannot condition the receipt of that service on you violating your sincerely held religious beliefs. So, I mean, I think there's a lot there that we could pick at, but I'd be happy to go in many directions.
Yeah, I'm sorry, my internet hiccuped, but we're gonna give it to Mike, and then we're gonna give it back to Kafka to answer to these charges. Go ahead.
Yeah, so I mean, you guys raised like a whole bunch of points, and I think it makes sense to go through them separately and individually. And I know we're also skipping through sort of my allegation that this is not originalist.
We'll get to that. I promise.
Which can be, yeah, we can do that separately because that's more of a broader discussion about the court as a whole. But for this, I want to focus in on the fact-specific nature of Yoder in this case, right? You guys are talking about Yoder, and I disagree with Lactoid's characterization of what the problem was in Yoder. It wasn't just that the Amish kids would be sort of exposed to society, right? That the concern of the court in Yoder was that by forcing these kids to go to school at all, even private school, it would destroy the Amish community entirely. It would make it impossible for the Amish community to continue to practice their religion. And so that was the scale, that was the extent, right, of the threat to the free exercise of religion in Yoder. Whereas here, in this case, I think it is important to talk about what is this ideology that these books are trying to impose on these kids, allegedly impose, right? I mean, I've read the books, I've read the opinion, I've come up with 3 ideas, and you guys can correct me if I'm wrong. The idea number 1 is that gay people exist and trans people exist. And that's really not an idea, that's just kind of a fact, right? The other one is that it's possible for gay people to be happily married. And that sounds like a fact to me, right? There are happily gay couples that exist in the world. And the third one is don't bully people for being gay or trans. At no point, none of these books, none of the instructions, certainly they don't tell kids to be gay or trans. They don't even ask kids to affirm or to praise LGBT communities, right? They don't tell kids to celebrate Pride Month. They don't really impose anything. They're just exposing children to the idea, not even the idea, the fact, right? That gay people exist, trans people exist. They can be happy in a gay marriage, and don't bully them. I mean, that's an opinion, I suppose, right? But I guess my question is, what of those 3 ideas really impair or threaten the free exercise of religion? Like, how does teaching children that stop them from being, or their parents from being able to exercise their religious beliefs?
You can go ahead and answer that, Ryan. I'm looking for.
Yeah, I mean, Mike, is your contention that you don't think that there are religious communities that teach that marriage is between a man and a woman, that there is no such thing as transgenderism? You don't think those exist? Or
okay, those are you just said 2 things, right? One is that marriage should only be between a man and a woman.
Yes.
And these books are not teaching kids what marriage should and should not be. They're teaching kids that it's possible for 2 men to love each other,
Mike,
be in a happy marriage.
At the end of one of the books, the 2 gay knights have a wedding and the entire kingdom bursts into applause. I think that it stretches credulity to say that does not express a view on whether or not 2 men can be married, and that's a morally good thing. Now, for the record, I am not a member of a religious community that has a problem with 2 men getting married. But to say that book doesn't have a point of view on that issue, or that there aren't religious communities that have a point of view on that issue, seems very odd to me.
Question for you on this, Ryan, actually. How is that different than portraying a straight marriage in a book in a school? Like, why is it that it becomes a religious issue for a book to portray a gay marriage, but if that were a man and a woman getting married and the kingdom burst into celebratory applause, why wouldn't that also possibly affect people who believe marriage is a sham and think marriage is maybe like an oppressive thing that was put upon people by the patriarchy or whatever, right? Like,
Because
what's
the
the difference?
Constitution doesn't protect ideologies, and it doesn't protect particular beliefs, and it doesn't protect quirky beliefs. It protects religious beliefs. And like the named plaintiff in this case, Mahmoud, is a devout Muslim. And in his faith and the faith that he's raising his children, they're men can marry women, women can marry men. That's it. That's the religious belief of that family. So I mean, I don't know what the confusion there would be. Their religious beliefs are not implicated by a man and a woman marrying each other in a negative way, whereas a man and a man marrying each other does implicate their religious beliefs. I mean, we are limited to the facts of the case in that sense.
On top of that, I also want to.
I was going to say, how's that any different from? I haven't had a chance to speak.
Yeah,
yet.
I want to
This
get
is my first one.
Kafka a little bit, and then we'll get to Lactoid.
I don't see how that is. While that may implicate a religious belief, I don't see how it burdens it. It in no way is telling them that their belief is wrong. It's saying, as Mike said, they're saying it exists. And you'd be surprised, Ryan, to hear this, but at most gay weddings, the people that attended celebrate. And so I don't think that is a wildly crazy thing to have in that book, that at this wedding, people are celebrating. I mean, I'd like to roll back for a second really quick, though. I would like to correct something Lactoid said earlier. He said that they were going to try to opt out of a lesson plan. To be clear, K through 5 in the school district did not have a gay rights or gender studies lesson plan. They had an English reading lesson plan. These books were one of many books that were contained within these lessons plans, and the school board did not require these books to be part of the actual lesson plan. The only requirement identified in the entire thing for these books was that they needed to be in the classroom and available for a child to take off the shelf. Now, a teacher could incorporate them if they chose to, which the Supreme Court has repeatedly reinforced a teacher's right to choose how to teach their lessons, so long as it's within, the guidelines of the school board and, no obscenity, things like that. But there's no requirement of these books to be read in front of the whole class, for everybody to read it, and there's no lesson plan. And it's important to talk about the lesson plan here because there are other opt-out provisions in the school district for specific lesson plans. The reason why this is an issue is because these lesson plans can't be avoided as a block. It is difficult for the teachers to say specifically when these books are going to be read and to plan ahead such that we can have the notices for them. Okay. Now, with regards to whether or not there's a normative message in them, I would agree with Mike that the normative message mostly is these three that he identified. But I think on top of that, the issue is then whenever you look to the reinforcement and the discussion around it, it is plainly obvious that those are the three intended ideas. The teachers were not instructed to tell children that they were wrong. They did never tell they always acknowledged, I understand that you believe that, and that's okay. They did not say then, but you have to accept that you can change your gender, or you have to accept that gay people can get married. They said that you have to accept people and respect them. They have different views than you, and you need to respect them. And I'm not sure how we can portray the freedom of exercise clause to say that it doesn't allow teachers to tell students they need to respect each other's beliefs. I think that's the fundamental basis of the freedom of expression clause, the freedom of exercise, is to tell children and to tell anybody that they need to respect each other's beliefs and respect other people.
Okay, so I wrote down the points and to make a couple responses. Regarding this being, I might use the wrong semantical term here when I'm referring to lesson plan. I'm specifically referring to these books being read to children, like the time set aside for these books being read to children, and the direction that teachers got. The specific term they used here was a page-by-page book discussion guide that directs how teachers should explain these books to children. That's what I'm referring to when I'm talking about like a lesson plan. There is a lesson and it's a plan. If there's a
you can call it semantics, but that word is specifically discussed within the opinion.
Right. Well, now that you know what I'm referring to, sure. Well, now that you know what I'm referring to, we can move on from that. What I'm referring to specifically is that. Now, when we're talking about the Knight situation, I think that you guys are skipping over some critical context. I agree the Knight book is not the worst of the books that were incorporated. But the whole theme of the book, again, is that, the knight, is he going to be with the princess? Which kind of girl is he going to be? And then at the end, he's with the prince, and there's a huge celebration. There obviously is like a normative kind of proposition here, which is that this sort of behavior is good and okay. And even if society expects you to not engage in it, it's okay for you to engage in it. And people should celebrate that. That is, again, antithetical to people's religious beliefs. The better example, like a more egregious example than the Knight example, I think is, for example, regarding Kate, the transgender child. Again, a transgender child, I think pretty relevant here. One page shows Kate in a sex-neutral or sex-ambiguous bathroom, and Kate proclaims, quote, "My friends defend my choices and place. A bathroom, like all rooms, should be a safe space. Intersection Allies includes a page-by-page book discussion guide, which asserts, when we are born, our gender is often decided for us based on our sex. But at any point in our lives, we can choose to identify with one gender, multiple genders, or neither genders. The discussion guide explains that Kate prefers the pronouns they, them, and theirs, and asks, what pronouns fit you best? As a question to ask the children. This, of course, goes beyond just like the exposure, or I guess the three things that Mike was talking about. Gay people exist. They can be happy when they get married, or don't bully. This goes to quite literally pushing gender ideology that is antithetical to their religious beliefs on children, or at least the parents' religious beliefs on children. And I do think that is a violation of the precedent set by Yoder. Again, when you say, well, Yoder talked about completely destroying the religious direction from the parents, it seems again like a matter of scale as opposed to a matter of principle. There's plenty of religious people who send their kids to school who perhaps aren't quite like the Amish. Perhaps they're of denominations that are less extreme, but their religious beliefs could be significantly hampered or essentially destroyed if this was a focal point of their religious belief. If their kids now, because their teacher told them to, or teacher said it was okay for them to, or asked them what their pronouns were, have this sort of belief in the possibility of transgender. So I guess those are my responses.
Let's say
real quick, I've got a very, very quick response, and then I'll let you take it, Mike. I agree that it's a matter of scale, and so does the court in Yoder. They specifically say this is an incredibly difficult and fact-intensive issue. They say that it's very, very unlikely that any other religious groups would even be able to get a judgment like this because of how specific it is to these Amish people. This decision today this decision they provided is so broad as to allow any religious group to succeed. Okay, so I agree with you that's a matter of scale, and the matter of scale is at issue here in this case. It is not the correct level of scale for the federal government to come in and involving themselves in this matter. Sorry, that's all.
Just to make, because it's easy for points to get lost.
Hold on, just Ryan, be quick, and then we gotta let Mike go too.
Yeah, just because it's easy for points to get lost in the extended back and forth. When Yoder talked about the kind of like the extreme issues that were there with the Amish, and they were talking that's in the context of the remedy being they get to pull the parents out of school. And there's a hydraulic between the action taken by the state that imposes on religious freedom and the remedy that the Constitution mandates. That's an extraordinary remedy, which was what the court was saying when they said that it really was almost unique to the Amish fact pattern. Like that would not be something that they would justify for a typical religion. That said, here, the remedy is so minor. Notify parents when you're going to be having lesson plans about these materials. If you're not going to have lesson plans about these materials, that problem solves itself. The case is not about whether the books can be on the shelf or not. That is not what this case is about. So notify the parents when the lesson is coming. And if it's really, really hard because you've woven them into your lesson plans for the English curriculum, don't do that. Make it Pride Month. Make it a discrete unit like you do for health, and provide opt-outs as as Montgomery County did previously for a year before this case began, and as they do for other subjects. This is like that aspect of Yoder that talked about the uniqueness of the Amish situation has to be read relative to the remedy that the court is imposing as a matter of the Constitution.
Hey, Mike,
I'll respond to what Ryan said first. I completely disagree that the remedy in Yoder was extraordinary in the sense of the burden on the state, right? It costs the state nothing to tell these kids, you don't have to come to school. But if you give these parents this opt-out right, and you tell, well, you have to adjust your lesson schedule, you have to make sure these kids sit out for this thing, and also for these other kids, they also have to sit out for this other thing. And, if you play Veggie Tales during recess, like you have to make sure that these kids have a separate area of the playground. That is far more burdensome to the state, or in this case, the school, right? Than to say, well, the kids don't have to come, right? And so I disagree with that characterization that Yoder, it was an extreme harm to the extreme burden, meeting with an extreme remedy. That's the remedy here is more burdensome than the one in Yoder. But
Mike,
to respond,
wait, hold on. In Yoder, the court said that a certain class of people have to be immune to the laws of the state. Flat stop. There is a law that says under the threat of criminal penalty, you must send your children to school. And they said, you don't have to send your children to school because the Constitution mandates otherwise. That is
but what's the burden
massive
on the state?
imposition on state sovereignty.
Your disagreement here is with the Supreme Court, not with Mike. The Supreme Court in Yoder says that it is a light burden on the state to allow these children not to show up compared to the burden they suffer.
What's the burden on the state here?
Fiscal burden. I'm talking about the burden on the state's sovereignty. I agree with you. It doesn't cost anything not to have them show up. That's free. But in terms of the state's capacity to legislate and control its citizens and to dictate policy for what we all, I think, agree is a compelling interest, which is having uniform educational standards within the state.
No,
that is a massive imposition on the state for sure.
I appreciate your novel opinion about. I appreciate your novel opinions about this, but I'm not familiar with a burden of sovereignty such that the Amish. The decision in Yoder is somehow unique because of this burden of sovereignty. I don't see that.
This case also burdens sovereignty. I mean, these are democratically elected, school boards, and this is a legislative decision. So this decision also burdens sovereignty.
Of course it does, to a much smaller extent. That's the hydraulic. It has a minor burden on sovereignty.
But the burden on the state is far greater than in Yoder. But okay, I don't think we're going to come to an agreement on that. But to your point, Lactoid, you said that there's this book with the trans kid and that is, more egregious than the Prince and the Night book, and also probably more egregious than the gay uncle marriage one, which I think we would all agree is sort of the least offensive one. But this opinion applies to all of those books, right? They didn't carve out a specific exclusion for trans books. This opinion applies to a book that we probably don't think personally is that offensive, which is the gay uncle one. And so you have to meet that where it is, right? Like if this opinion applies to the gay uncle, then you have to argue that it's correct in doing so.
But no, I think it is. The reason I brought up the trans one is I think that's like the most egregious. So when you're characterizing this as, like you said at the beginning, there's three things that this does. I gave you the most egregious example to show like this is not what's going on here. Like I guess in a way that's people can fully understand. I think the Night one and I think the Uncle one do that. I think they also have the sort of kind of lionization and implicit kind of pushing of the normative framework of the agenda. But I mean, the trans one is just like when you read that,
in what way
it becomes
does the
like
gay
apparently
uncle,
clear.
Hold on, I did read not all of the books, but I did read a few. And the Gay Uncle and the Night one were two I read. Can you explain to me and elaborate how the Gay Uncle one pushes some agenda? I did not get that from the text.
When it lionizes like the relation, like specifically like the relationship between.
Do you know what the story's about?
Like, I did read through them. The Gay one, Uncle one, I skimmed through. Could you just, I guess, go into that a little bit more?
So the story in that one is about a young girl who has a cool uncle that she's friends with, right? And they play and they do swings and stuff and very child-appropriate activities, okay? And one day he introduces his fiance, which happens to be a man, and the story is about she's worried that because her cool uncle is going to get married, that she's going to have less time to spend with her cool uncle, and her cool uncle won't like her anymore. And the whole story is about him reassuring her that won't be the case. And then they go through in this little, and they talk about it, right? How is that pushing a gay agenda?
I think, by the way, I think that is the most close to the neutral line of the texts that were involved, which is why it was highlighted in the dissent. And I think in my own, obviously I'm not a justice, but if it was that book standing alone with no other facts, I think that the parents would have lost. because I don't think that book alone would have carried the weight that they were looking for. But it wasn't standing alone. As I'm just read for the opinion. As one email sent by the principals reflects, the board selected the books according to a critical selection repertoire that required selectors to review potential texts and ask questions such as, is heteronormativity reinforced or disrupted? Is cisnormativity reinforced or disrupted? Are power hierarchies that uphold the dominant culture reinforced or disrupted? And the issue is, as a former teacher, there are books that I read to children because they are classics. They teach story structure. They teach characters. They teach the foundations of literacy. There were other books I would teach to children because they had a lesson. And I would whip them out when I wanted to teach that lesson. Don't be a bully. Be nice to your friends. Say please. There are books, and they're not written the same way. They're written in a way that is expressly normative. And that is a genre of children's literature. It is a genre that's commonly used in the classroom. All of these books fall within that category. They are expressly normative. And the issue is just whether whether there is a religious issue with using expressly normative books of this type with children who are so young that they don't really have the capacity to be critical about the ideas they're receiving. I think if it was just the book you flagged, Wick, the parents would have lost. I think if these were middle school students, the parents would have lost. But this was elementary school students, and it was in the context of a curriculum that was introduced specifically to be normative. So the fact that the Supreme Court finds it to be normative is hardly surprising.
Let's give it to Mike.
Well, so this. Oh, go on, Kafka. I think we're probably going to say the same thing.
I was going to say, we're not contesting that they're normative. We haven't contested that, and we keeps coming back to that for some reason. The normativity is not an issue, right? I think that whenever you look at these emails from the principal, and we see this a lot in the opinion of statements from a board member or people coming to a board meeting. Yes, those are all things that are happening. None of those evidence a religious burden. None of those have anything to do with finding a religious burden here. These are people saying these are the ideas that they're being exposed to. I have yet to hear anything here that constitutes something that would be a religious burden, even close to Yoder. If they're on the same scale, they're on the opposite ends of that scale. And one second, what I would say too is whenever I'm looking at these books and you're saying, oh, they're just like other children's books. Yes, there's normativity in a lot of books. And there's so many different religious beliefs that the normativity within those books would mean that we couldn't have any normative books. Because what if we have a Muslim family, and in many Muslim faiths, they find dogs to be unclean animals. And they come up and they say, I want to be able to opt out of my child having to have anything to do with any curriculum that shows a normative loading of dogs. That would eliminate a ton of books. What if you had a Jainist family show up and say, I want to get rid of any book that has a normative loading of eating meat, intentionally hurting or killing animals? That would remove a bunch of normative books. And you can go down the list of different things in different faiths, and all of a sudden now we don't have normative books at all, which I don't know if that's y'all's argument, but it's incredibly easy to connect any normative feeling towards an action or societal norm, and you will find a faith that might have an issue with it. And so again, we're creating this very, very, very low bar and very easy way to disrupt schools and disrupt the state's ability to educate children.
So and that's the issue with this opinion.
Sorry, Mike,
real quick.
This is just a short question.
Hold on.
Just a question. So there is no debate. These books are normative. We don't need to discuss that topic any further. You guys concede that point.
I can see that it's normative, but I disagree. Okay. I disagree on the gay uncle book that the normative lesson being taught is that like gay marriage is a good thing, right? I think the normative lesson being taught in the gay uncle book is that your cool uncle can marry anyone, and you can still have a very healthy relationship with your uncle and their spouse, right? Like that's the lesson being taught in the book. It just so happens that the uncle is gay, but that book itself is not trying to teach really anything about being gay.
Also, so, I would say, go ahead. Sorry.
With respect to the breadth of this opinion, right? Ryan, you said that, well, if it were just the gay uncle book, the parents might have lost. I mean, the gay uncle book is captured by the ruling, right? They could have carved it out, or they could have narrowed their rule so that books like the gay uncle book wouldn't be you wouldn't require an opt-out for that. But it does, right? You do have to the schools do have to offer an opt-out, even if they only have the gay uncle book under this ruling. And so that's why, like, if you concede that the gay uncle book isn't enough to sustain this rule, then this rule being broad enough to cover the gay uncle book is necessarily wrong.
No, that's not how this operates, Mike. In this case, the holding is literally that the parents are entitled to a preliminary injunction, flat stop. The question as to whether a preliminary injunction or other relief would be appropriate in a case with very different facts is not settled by this opinion. This opinion expressly says multiple times that the question of whether that a specific religious burden is on all fours with Yoder is a fact-intensive inquiry. So in this case, that book was one of five, and it was accompanied with all the other facts that the majority flagged as concerning to them about the nature of the board's actions in this case, including the fact that the board had provided opt-outs previously and then suddenly decided we can't do opt-outs. Now, in a different fact pattern, there might be a different answer. That's what a fact-intensive inquiry is. So I don't think that's a fair reading of the case, Mike. But beyond that, if we've conceded the books are normative, and we've conceded these are K-5 books, then the question becomes, at what point does teaching a curricula that involves these books of any type start burdening religion? For example, let's change the facts. These aren't LGBTQ books. Let's say these are books about myths. And it's a series of books. Santa Claus is a myth. God is a myth. Jesus is a myth. Mohammed is a myth. These are all things that people came up with. They're social constructs. They're stories people tell each other, but they're not true, children. Would that burden people's religion if that was a series of books that was being read to the class?
I don't think that's at all equivalent to what we're saying here. I think a better example would be, here's a book showing you all of the myths that have existed, and some people believe them, and they are out there, right? These religions exist. Some people believe them, and then if an atheist child said, that's all bullshit, the teacher goes, I understand that that's your belief, but you still need to respect other people's faiths. Would you say in that scenario, well, I'm not done. Would you say in that scenario, the teacher is now enforcing the religion on that child just by telling them they exist and that they need to respect those religious people?
The obvious reason you're not answering my hypothetical question is that it would clearly be a violation of the parents' substantial right to instruct their children religiously
because it's telling the kids they're wrong.
And you're clearly not answering my question because it blows your hypothetical out of the water.
But these books are doing that.
Exactly.
The guidance.
Parents at home are saying, in these cases, a man can only marry a woman. There is no such thing as non-binary. A man is always a man. There is no that's what these parents are teaching, and they're going to school, and the books are normatively saying your parents are wrong. Mike. That's exactly the point.
Under this ruling, could a parent opt their child out of a classroom that has a gay teacher?
No.
Why not?
I don't think so.
Because
the teacher has constitutional rights.
Brought up at oral argument, the litigants agreed that they would lose that case. The litigants also agreed they would lose if the book was just on the shelf. So I mean,
the teacher has constitutional rights. But let me respond to what Ryan was saying.
That would not be a problem.
Let's give it to Mike for a minute. Go ahead.
These books are telling the parents they're wrong about what, right? These books are not saying that gay marriage is okay under God, right? These books are saying that it's people celebrate. There exist people who celebrate gay marriage. That's true, right? That's not telling kids that their God is wrong about gay marriage, right? I mean, the kids and their religion, they can believe whatever they want to believe.
I want to, when you say like, oh, it's just depicting people celebrating, as if that's just like what's happening, as if that's just simply, it's look, it's a fact that people are celebrating. It's a fact that like people are saying good things about this. It's a fact that everybody is like okay with it. Like you could define any kind of normativity as just terms of like just description, if you want to frame it that way. But let's not have our heads in the sand here, right? When you have a child, a small child, who is under the control of an authoritative adult, and this is, again, they're being given these materials that celebrate this activity, when the discussion guides, inform the teachers what to do to further this celebration and to support this, I think that's fundamentally different than just like exposure, obviously. I do want to say one thing. I think the Bobby book, I think I did go too far when I said that is like pushing a particular LGBT agenda, like implicitly in the book. I think the other ones do. That one doesn't. But I do agree with Ryan that that's not necessary exactly for the right of parents to opt out. Because again, there is still a normative message in that book that I think religious parents could reject. And honestly, like, I would be okay. I guess this is just like looking at it. You know, you're sort of presenting this as like a slippery slope in terms of like, well, what if there's like a Muslim family who has like a really big issue with like dogs, for example, and you know, let's say the school has some knowledge as to like there are these specific books that like celebrate dogs and like depict them as being clean or and you know the guides say like, oh, if people don't like dogs, you know, hey, try to like get them to like dogs. um, I think Muslim parents should be able to opt their children out of those lesson plans. I think that'd be fine. I think that if you could find me like a fact comparable scenario where you have like the same kind of like books, the same kind of like guides, discussion guides, I'd be okay with that. And I don't think, I think that's like, people are kind of looking at that, oh, that's crazy. But I think the alternative is like almost somewhat ironically
I'm not.
Kafkaesque. It's almost like
I'm not going to call
1984
you.
shit.
Yeah, I'm not going to call you crazy, Lactoid. I think everyone can have their own personal boundaries on what they think is and is not okay to, teach children. I think the issue here is the Constitution require that, right? So, like, does the Constitution require that people can opt out of
When it comes to religion, yeah.
of books? And I mean, that's what we're disagreeing on. So all I'm saying is that, you or anyone else thinking that a book should or should not be read to children is not particularly relevant here for this analysis.
Well, no, but it is relevant if it's specifically like regarding a topic of like religious focus. If there's religious people saying this particular behavior is antithetical to our religious beliefs, we just don't want our kid to attend. And there's case law, right? Again, Yoder, there's Amish community. We have this particular religion. We don't want our kids to attend high school, right?
But the issue isn't just that this book or the story is antithetical to the religious belief, right? It's that whatever activity is involved here, in this case, reading the book out loud to kids, has to threaten, right, that their ability to freely exercise their religion. So I'll have to ask, like, what is the exercise, right? Like, what is the religious act that's being threatened by these books?
To instruct your children in your religious faith is the religious exercise that was discussed in the opinion.
I mean, that's so broad, but like instruct them.
Well, that's
to do what?
Yoder,
Right?
That's what's here. Like these are parents who, I'm going back to Mahmoud, the family that is the named plaintiff, who are Islamic and devout and have very particular views about marriage and gender. These are not views, by the way, that I share. So like it's not like I'm saying that everyone is entitled to this view, but I think that these are sincerely held. They are religious beliefs. This case was not decided. This case was decided on Yoder, so it was decided on res judicata and existing legal principles. But the idea that the state can push normative instruction that's contrary to religious faith on young impressionable children who don't know better and will internalize it as a normative value is, I think, something that warrants constitutional scrutiny. If the state could do otherwise, there would be almost nothing of religious exercise left. That if you don't protect parents' rights to teach their children to come up in their faith, that's the core of religion in many ways. It is the most central part of religion is the family and passing it down to your children. That's
not being.
It's all about.
I'd like
that's not being threatened, though. Yeah,
let's give it to Kafka real quick. Kafka, go ahead.
Then, Ryan, real quick. Then, what was some form of religious instruction that the parents were able to do before that they can't do now? What did the government taking away that opt-out program, how did that remove their ability, or remove is an extreme word, but even burden it? What were they? How were they instructed them? What were they instructed them before that now it has been disrupted such that the government needs to get involved? And one second, because I wanted to say that the issue is
exactly the same as it was in Yoder. In Yoder, the parents were totally free.
We do want to let Lactoid. Hold on, we do want to not Lactoid. We don't want to let Kafkaesque finish.
Sorry.
So let Kafkaesque get his whole point out, and then you can respond. I promise.
It's fine. I'll just say this again. I think if we're going to be appealing to Yoder, In that case, I would say it's entirely different because we were talking about 8 hours of the day in which the children are at high school instead of in the Amish community. At the end of that decision, they now are in the Amish community for 8 hours a day. Here, those kids go to school no matter what happens, and they come back and they get the same amount of instruction from their parents. And on top of that, what might happen is that the difference might be that they come home and they say, Mommy, Daddy, I read this book, and it says something different. And at home, they have their parents. I'm sure that if these people are devout, I'm sure they're going to their church or their temple or their mosque. They're hearing everything there. They're being reinforced by everybody in their life that they look up to about those beliefs. And that's where the contention is happening. It is not that the school is somehow interposing itself. Again, you are talking about these children being exposed. You brag about the case law of Yoder. There's also case law in Lee and in other Supreme Court cases in which children have to look at and see things that their parents don't agree with religiously, but for some reason the Supreme Court was able to recognize that, hey, you know what? That's going to happen. There's just no way to avoid that when they go to public school, especially in one of the most diverse counties religiously and ethnically in the entire country.
I do want to follow up just real quick to Kafka here with a question for you. You mentioned, at least to me, that one of the issues you have with this ruling is that it represents a possible kind of bigotry or bias on the Supreme Court. Is that a stance you still hold?
I would say that I don't think I would allege bigotry at this point. I think I would allege motivated reasoning and bias for sure. I think that there's a bias towards the religious people. I think that the Supreme Court is quick to coddle religious Americans. This decision almost it perfectly goes against their decision in 2022 and I believe it was Bower. I'm sorry, I always get the name mixed up when I say it out loud. In which a coach was able to a football coach was able to publicly pray in front of the entire school at a football game while he was the coach, while he was wearing a uniform, and after he'd been told not to. And they said, no, that's okay. It's okay if an entire school sees one of the head figures, leadership figures of this school pray. That's fine. But now if a book is on a shelf in a room, that is equivalent to taking Amish children away from their communities 8 hours a day. I think that this shows a severe motivated reasoning. I think that this case by itself does not show a kind of a bigotry, but I think this case, as well as the 4 recent shadow docket decisions, as well as, I apologize, there was one other recent case regarding trans issues with the Supreme Court that shows that this court does have at least some kind of interest in deciding cases regarding trans rights and trans issues. And so far, I've yet to see one that shows that they view them favorably.
Okay, I'll let Ryan and Lactoid respond to that if they wish. Then I want to bring up something that Mike said in his opening statement that we haven't gotten to yet, but I think would be an interesting discussion about how this is an anti-originalist decision, and I'm really curious to see if he's reasoning for that. But I'll let you guys respond, and then we'll get to that section. Go ahead.
I think, Kafka, you would have a lot more credibility in this discussion if you would limit yourself to the facts as they were actually articulated in the opinion. This is not a case about books on the shelf. It is expressly not a case about books on the shelf. That was a hypothetical that was brought up and dismissed by the named plaintiffs as being insufficient at oral argument. So I don't know why we keep saying that. It's just not what this case is about. But beyond that, I think that this case is on all fours with Yoder. Like what Yoder said is that by having the high school Amish kids in high school, they were unable to it would put a burden on the parents' ability to instruct them in their faith because they would be exposed to worldly influences and gone throughout the day. And there was an extraordinary remedy of them not having to go to school anymore at all. Here, you have parents whose religious instruction is being contradicted normatively, which we've agreed is happening in this case. And the parents, all they've asked for is notice and the opportunity to opt out so that their religious beliefs are not being contradicted for young children who look to their teachers as moral authorities. And we've all been young children, and we all know what it's like to be a kindergartner and look at your teacher as like a divine figure who speaks truth to you. I think that is that it is on all fours because the burden being contradicted by normative authorities at school is the same. The remedy is, in my mind, much less extreme, because here all you need to do is provide notice and allow for opt-outs, which this very school district was previously doing. And this very school district does for other subject matters like health. So the fact that they're not doing it for this, but they are doing it for other things, does make it a little bit suspect that they are choosing not to do this because they really want the kids to be in this lesson, and that is important to them for whatever reason it is. And lastly, with the example of the coach at the football field, it's exactly the sort of thing that we've been talking about here in terms of the fact-intensive inquiry. There is a coach who prays. Are you required by law to go to football games? You are not. Are you required by law to listen to the coach's sermon? You are not.
They can opt
These are
out.
all things that any student who was offended by the coach's praying could opt out of. The problem here is that the parents can't opt out. They're not even notified. So even if they wanted to pull the kid from school that day and just take an absence and risk some absenteeism issue or truancy litigation, they can't because they don't know when it's happening. So I think these are completely factually different, and that is the heart of this decision. Is a fact-intensive inquiry. You have to look at everything. It's not a black letter test.
I want to give Lactoid a chance if he wants, and then I'm going to let you.
I would
Kafka
really
respond.
like to address some things he said, but Lactoid, I'll give you your
Lactoid,
time.
then Kafka,
I mean,
then we're going to get to the next part of the discussion.
I mean, me and Ryan are basically in the same wavelength. He said what exactly he was going to say regarding the coach praying case. I mean, the whole question is, could those kids opt out from like engaging with the coach? They could. I think the problem would be if you said, okay, students, you have to go to not only football practice, but you have to go to this little prayer thing that the coach does beforehand, and you can't opt out. That would be a more analogous situation. And of course, I would fully support the parents' right to opt their children out of any such exercise.
Kafka, go ahead.
Okay. First, Mike, correct me if I'm wrong, but we did not agree. While we agreed there was normative loading, we did not agree that there's normative loading such that it goes against religious beliefs. The normative loading,
especially for the gay uncle book. But
to me, the normative loading is about respect and acceptance, which my understanding of the major religions out there is that is core in almost all of them. And if it is not one that I particularly care about us protecting. I do not believe that there's an interest in us protecting religions that exclude people there's not, I'm sorry, you could, what? Are you going to tell me that you can, that a racially, if there was a racially charged religion, do you think there's a racially charged religion? You think there's a religion based on racial superiority? If the Mormon cult, as it originally started, revived itself such that they believed that black people's souls were less valuable than white people's souls, and they showed up and said, you can't teach my child that all men were created equal, you think that the government should allow those people to opt out?
I think it's mask off that you said that you can be the judge of which religions are worth protecting under the Constitution.
Hold on. Everyone stop. I think
that the people want.
I'm not done addressing what you said before.
Hold on. Everyone, please, for the love of God, because he asked you a question, and I do want you to answer it. If there was a Nazi religion or something, or let's use
there's one that existed, Mormons, right? The original text of the Mormons.
A little different. I grew up Mormon, right? So it's not exactly as you.
Let's stick with that example,
right? But let's go with it, okay? Yeah, they came up and said, you know what? I don't think you should be teaching my kid that black people and white people are the same, and I want to opt out from you reading this book that shows them as the same. Should that be allowed for the parent to be able to opt out from that?
Well, there is a sincerity test that it's not much litigated because it's essentially given as a granted.
Just grant that they are very sincere.
So we're granting that they are sincere.
Yes.
And are we granting that there is, what religion are we saying this is? Is this a make-believe religion?
Fundamentalist Mormons.
This is a hypothetical religion?
Fundamentalist Mormons.
This is Mormons.
Back in the day had the mark of Cain, right? They believed that black people did not, there's a few different theories, but one of the major theories I've heard growing up was that some people believed that because in the pre-existence, in the war in heaven, certain souls didn't fight as valiantly as other souls, and so they were put into the bodies of black people, basically. That was a real belief that they had and that they sincerely held. Again, if a parent that believed that sincerely was like, I think that this undermines my religion. I don't want you teaching that black people are the same and equal to white people. They sincerely held it. Do you think that the government should force the school district to allow that parent to opt out?
Probably, yeah. Like that's what
Okay.
I don't think the First
Can I-
Amendment is
can I-
based on the quality of the religion. I don't think there's anything in the text that says that we only favor good religions. In fact, to be totally candid with you, the kind of fundamentalist Islamic beliefs that are at issue in this case are deeply offensive to me. Like, there are many tenets of that particular faith that I find offensive. That has not stopped me from representing
That's fine.
clients. In fact, litigating at the Supreme Court in defense of Muslim clients' religious rights, though I disagree with them. And it would not stop me from litigating
This is a
in
tangent.
favor of a client who had a religious belief that I found to be personally
Well,
abhorrent.
to be fair
because
to
I am
Ryan,
not the judge
he's
of what someone's
biting the
religion
bullet. Is
is.
what Ryan is doing here. He's biting the bullet.
Can I have an opportunity to? Can I have an opportunity to bite a bullet as well?
Okay, and then we're gonna give it back
so-
to Kafka to finish his point. Sorry.
Well, I'm going to bite the bullet, but then I don't want to get distracted as to the mask-off moment that just happened, because Ryan was in the middle of going through that when he ended with that very provocative question to kind of capture the attention towards that. The question is, like, Mormons assume, because this is, by the way, since abandoned belief of Mormons.
Yeah,
the current, my understanding is,
hold on, just a history lesson here. This was a contested thing. The Joseph Smith originally gave the priesthood to some black people, but then Brigham Young became the new prophet, and the Mark of Cain thing started going around, and there was an explanation that needed to be given as to why black people weren't getting the priesthood, and this was the belief that was one of the beliefs that was given and sincerely held by several people for quite a few years. And then back in the 70s, the church changed their position, and here we are. So.
Sure. So let's assume that we're talking about specifically, like, if any of them exist, Mormons that do sincerely hold this belief, or I guess going back, you'd probably find more of them. Yeah, I do think that they should be able to opt their children out of that. I do think that's a religious conviction. I do think that they should have the right to opt out. And I think that it's very telling, that we would answer this, because, of course, we're approaching this from sort of like principled legal perspective. Meanwhile, right, I think you very specifically said you have no interest in protecting religions that you deem to be intolerant. Well, it doesn't matter what your interest is. The question here is, what does the law protect? And does the law protect people's right to practice their religions and the parents to direct the religious upbringing of their children? I know, maybe you don't have an interest in protecting, maybe you wouldn't represent them. Maybe you don't have an interest in protecting religions that you find to be abhorrent. For me, I find a lot of religions to be abhorrent. But that, again, the Constitution protects religious belief, point blank.
And just to put a bow on that, this is in the context of the First Amendment. I mean, imagine how crazy it would be if someone said, I only think the First Amendment protects speech that I think is good speech. This is the First Amendment we're talking about. Like, it is designed to protect people whose beliefs are considered abhorrent by the majority. That is what it is for.
Okay, Kafka, finish your point, and then I want Mike to give Mike to respond as well, and then we're going to move on to the next segment. Go ahead.
Yeah. I don't have an issue saying this whenever I'm saying, I didn't say that we can't protect religions that I might disagree with. I'm saying that the idea that we can't teach a child that men are created equal, one, Thomas would agree with me because he believes in the traditional teachings, and that has been traditionally taught for quite a long time, so he would support me with that. Two, there are multiple decisions that discuss the necessity to educate children based off of what we would want as citizens of our society. And the discussion around hatred and hatred ideas have come up, and we're not protected, allowed such that those people that have those ideas could somehow enforce them on the school district and require that school district to impose a burden for them to maintain them. Those are out there. I'm sorry I didn't bring them with me. I didn't think I would bite that bullet. I genuinely, I don't mind finding it, sending to talking about it again. I don't mind.
We're too principled.
Yeah, I know. That's fair enough. Now, real quick, one thing, because the football game case came up, and I don't mean for us to get back into it again, but I'm sorry you guys are just blatantly just not even really thinking about what you're saying. Lee versus Wiseman was almost exactly the same thing, in which they asked, there was a prayer that happened at a graduation ceremony in which they said, no, you guys can't do this. People could opt out. They didn't have to go. The school hosted a ceremony. They brought this person in, and that person, on behalf of the school, said a prayer. It was a religious leader, right? And they said a prayer. What's happening here? We have a sports game being put on by the school. The coaches brought there by the school, and then he does a prayer in front of everybody. All right. And then, okay, not only that, he was inviting students and other faculty to come and pray with him. Now, let me ask you this. If there was a classroom and a Muslim teacher played the call to prayer in it and said, hey, everybody, if you want, you can get on this prayer mat and pray with me. Do you think that's an appropriate action for that teacher to do? Or, hey, actually, guys, you're right. That's a compelled one. The students are there. So maybe a weasel way out of that way. Let's say this. Let's say we're at some kind of event where people could just show up. And the same thing happens. A teacher says, hey, I just played this call to prayer. Any student that wants to, why don't y'all just come on over and pray with me? You think that's an okay thing for a teacher to do?
Man,
that works at school.
I played football. I went to many of school events that were optional in which there were prayers. I did not participate because I was not religious. So this does not strike me as nearly the same thing, because there are opt-outs on top of opt-outs on top of opt-outs. Nothing in that fact pattern suggests that anyone was forced to pray. No one was
literally said that in there. They addressed every single one of your points right now.
Literally optional. The issue that we have in this case is that it is not optional. So when you try to compare these two things, it falls flat because they are categorically different in the most important way that matters.
Well, so let me just go into, I guess, my closing argument. You know, I think we went off a tangent on like whether some religions are worth protecting or not. That's not particularly relevant to the analysis in this case, which is that is Yoder, right, analogous to what's going on here? And you know, Ryan, you said that it was. I disagree, and I think you mischaracterize, right, the scope of the problem in Yoder, the scope of the threat and the burden on religion in Yoder, and you really play up the burden in this case, because in Yoder, again, to use the majority's own language, right, forcing those kids to go to school in high school would have destroyed the ability for them to be Amish, right? It would have killed the religion. That's the burden. That's the threat that was in Yoder. The threat here is not destruction of Christianity or Islam in this case, right, or really any religion that's opposed to gay marriage. The threat or the burden, you know, to the extent there even is one, is simply reading a book. I know you guys don't like the word exposure, but so I'll use the specific facts. It's reading a book to children who have to, you know, I guess they could choose to not listen, right? But they have to be in the room when it's read. And, you know, if a kid says something, you know, about like, well, it's not right for gay people to be married, the teacher doesn't say you're wrong, right? The teacher is not supposed to tell the kid they're wrong. The teacher says, you can think that. There are other people who disagree, right? So that's the burden we're talking about here. That's the threat we're talking about here, which is nothing close to the threat in Yoder, which again threatened the entire existence of the religion as a whole. And so that's my closing statement on this point.
Yeah, I do, right, because we're just going to circle around on this again. I do want to, and I'm going to toss it right back to you, Mike, right, because you made a statement in the beginning that I do want, it's interesting to me to talk about, and I do want to talk about it, that this is an anti-originalist decision, that it goes against the originalist ideas of interpreting the Constitution as it was intended to be interpreted. Elaborate, and then we'll discuss.
Yeah, so before I go into my argument, I think it's just helpful for non-lawyers listening to know what originalism is. And, you know, the originalists on this panel, correct me if I'm wrong. But it is a legal theory for interpreting the Constitution, right? So if the Constitution says something, we need to figure out what it really means. Originalism is the legal theory for doing that. And what originalism says is we look only at the meaning of the text when it was written. And to figure that out, we look at the historical context, right? Whatever. But that the idea is that the meaning of a constitutional amendment is fixed in time when it was ratified. And we don't and by the way, originalism trumps precedent, right? Like in Dobbs, for example. It doesn't matter what the precedent is. We do an originalist analysis. And if the precedent says otherwise, it doesn't matter. Same with Trump v. Casa, the universal injunction case. Doesn't matter how many times the Supreme Court has refused to stay a nationwide or universal injunction, right? Doesn't matter the practice, right, for decades. Whatever the Judiciary Act says, right, according to originalists, is what governs, and that is the rule.
Is before you go on, do the originalists agree with that interpretation of?
I think it's a little. I think it's a little bit too general in the ways that really, really matter. So there are different schools of thought on originalism. I would subscribe more to like the Justice Scalia version of originalism rather than the Justice Thomas version of originalism. And they are meaningfully different in this specific case. So if you'll just give me like a little bit of leeway room just to lay that out. So you said that a few things I agree with. Originalism has a fixed meaning of the Constitution, and you look to how a clause was publicly understood at the time it was enacted. That's all correct. I think we all agree on that. Justice Thomas's version of originalism is that is the North Star. And all case law that went the other direction is inherently wrongly decided. And that's why Thomas concurs in cases like this one, because while he agrees with the outcome, he would like it to be an originalist inquiry. And as I think Kafka mentioned, he gets into whether this was a traditional issue, whether this was a traditional religious burden, whether this was a traditional instruction in school, and starts doing that sort of analysis in his concurrence. Justice Scalia's version of originalism, which is mine and Justice Barrett's, you can't unring the bell. Like, just because if someone asks, can the judiciary rule whether a law is constitutional, you don't get to ask whether Marbury versus Madison was wrongly decided. There is case law. The case law is interpretive. The case law is binding and is entitled to res judicata unless, as in the case of Dobbs, it was egregiously wrongly decided. And unlike Thomas, something being egregiously wrongly decided is not merely because it goes against originalist principles. In this case, applying Justice Scalia's version of originalism, I don't see any problem at all. The analysis says, well, we have to ask this question about the Constitution. How are we going to analyze it? What do we look to? Well, Yoder interpreted the Constitution already. We believe, and the majority believes, that this case is on all fours with Yoder. So Yoder already decided this question. There's no need to reinvent Yoder because Yoder is good law.
I do want to.
I think that your criticism would extend to someone like Justice Thomas, but would not extend to an originalist who has a little bit more of a Scalia bent.
Well, we haven't heard his actual criticism yet, so we don't know. But I just want to take this time to say, hey, gang, there's 101 of you on YouTube watching, and you have 12 likes on the stream. What the fuck? Okay. Is this not good content? Do you not like the stream?
I'm sorry, I didn't like the stream. I'm going to
go
help get those numbers
like
up
the stream,
right now.
And gang, give me money. Like, seriously, I'm not doing this shit for free. Super chat this shit. Okay, yeah. Mike, give us your argument. Give us your argument for why this is anti-originalist. And then we'll get to Lactoid, I promise.
Because I got a little bit of different definition than Ryan, but go ahead, Mike.
Okay, I do think we should iron out the definition before we go into the arguments. So I agree there are different forms of originalism, but Justice Barrett, who authored Trump v. Costa, the universal injunction case, right, also eschewed longstanding Supreme Court practice. And so, sure, right, I think what happened when Scalia was confronted with Brown versus Board of Education, and for those who don't know, that's the school discrimination case, it's a typical gotcha used against originalists, which is, well, when the 14th Amendment was ratified, schools were still segregated, and they remained segregated for decades. So how can you square originalism with Brown versus Board of Education? And judges like Justice Scalia and Justice Barrett, they, instead of saying Brown versus Board of Education was incorrectly decided, they treat that case and some others like it, Loving v. Virginia maybe, as, to use Justice Barrett's words, super precedent, right? Like, these are things that we would just never overrule just because. But that is, again, there's no underlying principle to that. It's just that they think the outcome is particularly good, and I agree. But why is, Brown versus Board of Education, which may not be on solid originalist grounds, so much better than another case that maybe they disagree with the outcome on? This is going into originalism and not really my argument, but Lactoid, why don't you give your definition, which is different, I suppose?
Well, slightly, maybe just, it's not totally different. It's just like some more nuance. I think that originalism encompasses like this sort of, when you're talking about textualism, like a more textual originalism, which there's looking at the words from the historical time period that they were written. There's some, I guess, a more modern form of textualism that some people practice, which is just look at the words now. What do they mean now? I think that's bad for a couple of reasons. But I think there's this other one, which is like intent originalism. I think that is, when I think the court is often doing this when they, for example, talk about, digging back in the past for analogs, digging back in the past for, like in Dobbs, for example, what did the lawmakers who were drafting the 14th Amendment intend for this to apply to when those exact same lawmakers were going on to ban abortion? Well, clearly they didn't think the 14th Amendment protected abortion if they went then to go and ban abortion. So that is evidence as to what their intent was with the 14th Amendment. That's sort of the religion or kind of originalist that I am, right? I think the intent does matter. The intent of the people creating the law at the time. And so, when it comes to this case, I guess I'll hear your argument, but I'm just skeptical that at the time of the drafting of the First Amendment, or maybe even an incorporation of the First Amendment during the 14th Amendment, that the drafters didn't believe that parents could opt their children out of lessons, and especially ones regarding celebrating homosexual behavior. I think that
you don't
really
have to
would have
get
been
that.
allowed.
You don't have to be that specific.
I want to buy.
Okay.
Well, I want to buy one more bullet, and then you can. I have said multiple times in the past. I actually do think that Brown versus Board was wrongly decided, and I do think that this appeal to super precedent is just inconsistency. I think it is just this sort of like, we really, really don't want to overturn this because look how bad it looks. So we're just not going to touch it. And you could say for some period of time that was Roe, but then the wind shifted, and I guess people grew balls.
And these are legitimate.
I do.
different
Hold
schools
on.
of
We're gonna.
thought.
I don't want to get like too off because I want to give Mike time to actually get his argument out because we have limited time. I want to get to this discussion, right? So Mike, give us your argument, please.
So what this case does, right, is it crafts or solidifies a personal right, right, a right in parents to opt their children out of a school activity on religious grounds, right? Like that's the right that, I don't want to say created, but the right that has been enshrined in this opinion. When the First Amendment was ratified, and also when it was incorporated, right, school prayer was mandatory. And school prayer remained mandatory until the school prayer cases, I think in the 50s or 60s. So for hundreds of years in American history, you could not opt your kid out of school prayer. Your kid had to go to school, and they had to sit through school prayer for hundreds of years. And so there has never been historically, right, if we were to be principled originalists, there's never been a historical right analogous to this one, where parents get to pick and choose, right, which school activities their kids would participate in based on religious grounds. School prayer was mandatory for the entire time. And so how is this originalist?
Well, I mean, a few things. First, there are different schools of originalism, as I mentioned earlier, and at least kind of the Scalia-Barrett version that I ascribe to, we never actually get to that question in this case because it's decided by Yoder, and Yoder is good law. So there is no need to do that traditional analysis, which is why the justices didn't do it here. But if one were doing the traditional analysis, let's say you were doing more of a Thomas style of originalism where you have to go back to first principles each and every time, even if there is good case law that decides the issue, Mike, school was optional back then. Maybe prayer was mandatory within the school, but you didn't have to send your kids to school at all.
No, the
idea that school became mandatory was quite a bit later.
There wasn't even public school at the time of drafting. Yeah.
Yeah, but then any right with respect to public school wouldn't have existed at the time of drafting either, right? Like it wouldn't have been in the minds of the founders to create this right. Because
the public school wasn't in the minds of the the idea of the government compelling children to go to school wasn't in the minds of the founders. This is like of a fundamentally different nature. This is why
and neither was universal injunction, right? But if neither was universal injunctions, but because right? Like I mean, I'm trying to hold the court consistent.
The universal injunction case wasn't decided on constitutional grounds, right?
It was decided on originalism, the argument.
Yeah, but on top of that, refusing to hear something isn't
interpreting the statute, not the Constitution.
With originalism as the legal theory.
Originalism.
I'm talking about consistent application of the legal theory.
Yeah, I think
whether it's a statute or the Constitution is this.
Your use of that case is wildly off. They looked at whether the courts were authorized to do universal injunctions, and they said no. And there
And to
were
answer that question, how did they answer that question?
they looked at they looked at what was authorized at the time that the courts were created, of course. But there's nothing inconsistent about that. They looked back, they said, no, you're not authorized to do it. What's
And there was no
problem with it?
precedent. Refusing to hear
And
a
why
case
not
is not
look back
precedent.
now and say, no, there was no right anywhere close to this one?
Because Yoder exists. There's binding precedent.
No, we're in a world where we're looking back, right? We're in a world where we're doing the originalist analysis of looking back.
Let's arguendo for a minute here.
The court looked at Yoder, said Yoder decides the case. We don't need to look back any further. We have Yoder. Now, if the majority was 6 Justice Thomases, they would have had to look back because his type of originalism demands that, but the majority didn't do that because that's not required by originalism flat stop. It's certainly not required by the version of originalism that is practiced by Scalia and now Barrett. So they looked at the case law decided the issue, you're done. Originalism doesn't require you, unless you're specifically a Justice Thomas disciple, to go back and reinvent the wheel in each and every case. You still have case law.
Okay, so to be clear,
so we're in the world where we're doing the Justice Thomas analysis, right? I mean,
that's not what the majority is not Justice Thomas. You're accusing them of hypocrisy, but the majority don't believe what Justice Thomas did. That's why he writes a concurrence, not the main opinion. If they agreed with Justice Thomas and the majority all held his judicial philosophy, he would have written the majority opinion, not the concurrence.
But so then you'd agree at least that under the Justice Thomas theory of originalism, right, we would need a historical antecedent. We would need a similar right to have existed, right, at around the time of the First Amendment was ratified or incorporated when the 14th Amendment was ratified, right? So do you agree with that at least? If we were doing the Thomas analysis, that we would need some analogous right to have existed at the time to also give parents the same right?
I didn't dwell on his concurrence because it's not my judicial philosophy, though I admire him as a justice. But so I don't want to go too hard on that because I'm honestly not sure. I do think that would be part of the analysis. The other part from my skimming of his concurrence would be whether the state's practice here had historical analog and whether there was some historical precedent for the state teaching, gay rights or gender equality or that sort of thing.
It's not. That's not the precedent you need, right? It's not a precedent of teaching gay rights. It's a precedent of allowing parents to opt out of school activities based on religious grounds. That's the analog you need, right? So, okay, fine. We can punt on the historical analysis here, but then how do originalists pick what's good law and what's not? That just seems like they're picking and choosing the outcome that they want, right? Like, this is the good precedent, so we're going to follow it and not do the Thomas analysis.
There's a test. You ask whether something is egregiously wrongly decided. There's case law on that. It's not like
they determine egregiously wrongly decided based on the preferred outcome.
No, they're judges. They determine it based on their legal principles. Like if you ever listen to Scalia talk about Roe v. Wade, his problem with it was that it was, he thought it was wrongly decided. He thought that it was egregiously wrongly decided and that the right was invented whole cloth. But more importantly, his problem with it was that it put it, and especially its progeny Casey, put the court in the position of being the legislature. They were just making things up. They were saying, oh, well, now it's the first trimester. Now it's an undue burden. What's an undue burden? Nobody knows. They're just inventing things full cloth, which gave the court no standard going forward, which is why he thought that was egregiously wrongly decided, but why, other cases that he totally disagreed with, he would have said, yeah, res judicata.
But that's true.
I think point Loving and so like interracial marriage and a number of other cases, Scalia would have said, well, I wouldn't have decided.
But that analysis applies to all of the substantive due process cases. Those were all the court legislating, right? Like Loving v. Virginia is the court deciding that that interracial marriage is okay. Like, why would that analysis apply to Roe v. Wade but not Loving v. Virginia?
Hold on. After you answer it, I want to give Kafka the mic. He's been trying to get in, right? He doesn't have a camera.
Sorry. I didn't notice.
You're fine.
Mike, it's fine. You're handling this way better than I ever would.
Oh, okay. Fair enough.
This is outside of me. I just had a few things I wanted to put in there alongside this. So you go ahead with your response.
Yeah, respond, and then I want to get Kafka in. So.
I mean, it's been a while since I've listened to Scalia's lectures on this, but as I recall, his answer to that question was because Loving and like the interracial marriage cases and those cases created applicable standards that judges could apply without putting themselves in the role of a legislature. Whereas when you look at like Casey undue burden, the judges are both inventing the standard, and then every time a case comes before them, they have to say, well, this law says that at 15 weeks you have to have a consultation and a sonogram. Is that an undue burden? How do we know? I don't know. There's nothing for us to look at. Let's just sit around and make it up. It makes the judges become legislatures because there's nothing for them to do other than they can't act as lawyers. That was Scalia's problem with the case, in addition to the fact that it was wrongly decided under originalist interpretation of the Constitution.
Okay, before Kafka goes, I'm going to read these 3 super chats real quick to encourage people to keep giving me money. $10 from Alexander Rin to say, read whoever directly responds to this as a question. And the question I saw was, why is Lactoid so fat? From Short Stack Goblin. So, I don't know. $5 from Testicle Johnson to say, yes, the intent. So the intention is only rich, white, male landowners should be allowed to vote, right? That is an originalist interpretation. And then $5 more from Testicle Johnson to say, I'm fine with the 10 Commandments in classrooms as long as the 11 satanic rules of the earth is right beside it. And thank you for the money. Okay, Kafka, mic's to yours.
To be clear, I think the white, rich landowner voting thing would actually be more of a textual argument, considering it was kind of written in there. But jokes aside, one, there was just kind of a misstatement earlier. We hit a compulsory education for children. It predates America. Massachusetts had it back in like the 1640s. So that existed. We can't discard originalism simply because this concept was outside of the bounds of their reality. It was within one of the colonies, one very close to Maryland. Then as far as you guys, the super chats really threw me off. I'm sorry.
Apologies, I just got to make a little money, but go ahead.
No, don't apologize for that. Let me see. I will say, to give myself a little bit of time, I have to admit that unfortunately, despite my political leanings, I do actually like Thomas and his writing. So please, everybody, forgive me for that. But he actually is not terrible. But here it is. You mentioned that the issue, say, in Roe is that we're creating this idea of undue burden, things like that. Whereas in this case, we are also creating ideas. We are doing the same thing here. We are creating this idea that a psychological effect from a book, that a potential threat and an imagined threat by a parent can be a religious burden. And to me, in the reading of this, that is why, for me, I don't see the equivalence to Yoder, is that it's clear that Alito has to create new language to describe what is going on for it to be comparable, because otherwise it does not reach that burden. So that's why, to me, I think that like whenever you're talking bad about Roe for those reasons, I think that it can also be then applied to this very decision.
Responses.
I would be delighted to be proven wrong on this. I'm looking at info, please, state compulsory school attendance laws. I'm not seeing anything before circa 1870-ish, but I mean, if there's something you'd like to point me to, I would be delighted to be proven wrong about that. This is the information I have, and
I don't think it's a super big point. I just was going to say that's there. If there was an idea, I can send it to you. I don't mind.
Sure. And then in terms of undue burden,
again,
I think that the reason that I brought up undue burden, which was Casey, is because Mike asked what makes Roe and Casey, to an originalist, the type of decision that is vulnerable despite being res judicata, whereas something like Loving or the interracial marriage cases, at least to me, are not vulnerable. And the reason I gave is because it put the court in the position of being a legislature where they both invented a right and then they've invented a test, and the test has no standard attached to it. So now they're literally just deciding ex ante what the Constitution says in each case based on nothing, because there's no legal reasoning they could do in order to determine the outcome. It literally is just them making stuff up, that was the problem in that case with a standard like this. Here, the court has expressly said this is a fact-intensive inquiry. This does not create a a black letter, bright line rule that can be applied to other cases. It is going to have to require looking at the facts of each case in each instance for the case law to develop. And like I said, I suspect that as more cases are brought with different fact patterns that maybe have more sympathetic books, more sympathetic boards that don't say such incendiary, crazy things to the parents, calling them transphobes and bigots, etc., at various meetings, and isn't coupled with this being for young children who are impressionable and not likely to be able to disaggregate ideas that their teachers present, that you might get a different outcome. And in fact, I think you would get a different outcome. But we haven't seen those cases yet. I'm sure we will now that this case has been decided, but each one will have to be evaluated separately.
Do you contend with the idea that this case does not have a sufficient record to be decided like this? Because that was an issue brought up by the defendants the Fourth Circuit and the defendants, and also the DC court brought it up. I think that what I'd say, one second, real quick. I think that it's possible for them to have done it. I'm not saying it's impossible for them to have done that, but to me, I didn't see anything in there that alleged an actual burden. It was all imagined burdens or ones that they felt existed and thus took action. Do you dispute that?
I think it's a wildly unfair thing for clever defense counsel to have raised, because very clever counsel says, wait a minute, you have no evidence of what was done in the classroom. How can you prove that? And of course, the parents have to say, well, we have no evidence because you never notified us when it was happening. We're not in the classroom. Our kids are unlikely to be good witnesses and would be hearsay in any case. So, and I'm certainly not going to be brought into court. So, of course, we don't have this information because you prevented us from having this information with the very policy we're contesting. So, no, I don't think you need to have that sort of evidence for a temporary restraining order or preliminary injunction, in a case like this. I think in this case, in fact, the parents were precluded from having that information.
Do you acknowledge
they were precluded from the notice, but the notice alone wouldn't have been evidence of what was going on in the classroom, right? I mean, you subpoena the teacher to get actual testimony about what was said. The notice is just going to be, hey, we're going to be reading these books.
They know who their teachers are. They could have subpoenaed them for a PI hearing.
Yeah.
It's not insane.
Yeah, but the facts that they need are like, what did you say to the kids when they were like, gay marriage is wrong, right? What did you tell the kids to do, right? Because reading to kids is different than telling them to do something. So these are the facts that aren't going to be in the notice anyway.
That's a very, this is more of like a brass tacks practical lawyer issue. That's a rough deposition. Can you imagine? You have no evidence. You have nothing you can call the teacher out on. When you're deposing a witness, and for non-lawyers, one of the tricky things is when you're deposing a hostile witness, they are not inclined to be helpful. They are, in fact, inclined to be very unhelpful to you. So when you ask them a question and they're giving you an answer that you suspect might be misleading or wrong or mischaracterizing things, you have to have a document. You have to have some evidence you can point them to that rubs their nose in it and makes them admit what's right and what's true. In this case, parents are really going to struggle because they had no notice.
That could be the testimony from their kids. It doesn't have to be admissible. It could be hearsay, but they could use their children's testimony for the deposition.
Sure, and then
right? Like my kid said, you said this. Did you say? Well, then they're lying, right? I mean, that's a problem with every deposition.
Well, it's difficult to get evidence is not a reason to not provide evidence.
Well, it is when you're talking about a preliminary injunction, and the question is, do you have to let constitutional injury occur so that you can get a court ruling saying that it should stop? And the whole point of a preliminary injunction is to prevent it from occurring. So in a case like this, where the injury seems imminent, it seems like this is certainly going to happen. By the way, it's been 2 years since this case was brought, so they haven't had an injunction all this time. So the injury almost certainly has occurred, but we're limited to the record of the case as brought at the PI stage, so we can't use any of that evidence. I think it's more than fair game in a situation like this.
I do want to hear a Lactoid's opinion, but also I got a super chat to ask him from Dave Timmerman for €2, I believe. Wick, why was Lactoid here? Because I invited him. I don't know why else. Why is anyone here? Lactoid, why are you here?
I'm fat, and why am I here? Clearly, your audience loves me, Wick. Okay, a couple things. No, my understanding was similar to Ryan, and I've been looking into it while this has been going on. And I think my understanding is correct that compulsory education, in terms of like the state mandating compulsory education in public schools, really was not a thing at the founding of the country. And in fact, going back, there are when you start seeing a lot of this legislation happening in the mid 1800s, there is one case I was able to find from 1890 in which this actually did go to at least the Wisconsin Supreme Court, and they did rule in 1890 that you could not use the Protestant Bible because that was infringing upon the rights of Catholic students. So you can't use the King James Bible, which was being pushed by Protestants. And this was really at a time in which, I mean, anti-Catholic sentiment was pretty high. We're talking about 1890s. So I think that you can do a. I know Ryan has perhaps places more weight on case law than I do. But I think that you can do like a actual like intent-based originalist understanding of, when the founders were drafting up the country and they're drafting up the First Amendment, at around this time, did they believe, especially when they were trying to get away from the Church of England, when they were trying to establish religious kind of some level of separation between church and state. Obviously, there's some military is a little bit different, but there really wasn't this compulsory education, so you could just opt your kids out. I think that's a very strong originalist argument. If you don't buy that, if you want to look at the precedent, I still think Yoder is pretty damn good precedent. And I guess those are some responses that I had for the prior points. Was there a specific question that I missed in the meantime?
I had one for you. This one actually, I didn't want your opinion because I'm not a big originalist guy, and in thinking in those terms. But I do actually want to pick your brain about something real quick. Cool. No disputing what you just said right now. Just let's think about this. Do you think that the founders, their intent in writing the First Amendment and writing the Constitution, they had an intention that the federal government would be able to dictate to a state-run school and a state how to run that school, such that this would be allowed in their intent? You think the framers had an intention that the federal government could insert itself such that it could tell a state how to run a school that it is conducting?
Probably not at that time. Again, even states didn't have compulsory education laws at the time. But at that time, my understanding is really the sort of idea of the Bill of Rights really like coming down on the states was incorporation following the 14th Amendment.
Yeah, I think that at the time that the Constitution was originally ratified, the First Amendment didn't apply to the states.
Right. So then,
the originalist inquiry would not be at that time. It would be at the time when the Bill of Rights became binding on the states.
Potentially.
Which you all agree.
That's a tough argument.
Sure. So then let's say, then y'all would agree in the 1850s and onwards, there were public schools by the states, and the writers of the 14th Amendment would have been able to incorporate a concept of public schools and compulsory schools at the time the 14th Amendment was written. And then now this could be discussed then in an originalist context if we didn't have Yoder, let's say, right? And which in Yoder they do discuss the First and 14th Amendment and those things. There was the rights that are granted by them there is where they've kind of carved Yoder out. And so I feel that whenever we're looking at an originalist text, we're not, as y'all have said, we aren't looking to the founding. We're looking to when the 14th was written. And so
I don't know about that.
Okay, so if we're saying in the founding, we're not the government. The founders probably didn't have an idea of doing this kind of intervention by the federal government at the time of the 14th Amendment writing. If we were to do that one, do you think that those writers would have had an idea of the federal government being able to dictate to state schools?
I understand the argument, and my point is, like, I'll have to actually think about that one a little bit more because that's a difficult question.
I have no idea.
Right, because the question is like, okay, so we have the First Amendment, the founding was intended to do X, Y, Z, and then there was an incorporation. So the question is, by applying this thing, by going back and taking the thing that we're looking at from an originalist lens, and then applying that in a novel way, does that change the fundamental meaning of the First Amendment? I don't know. So I'll think about that one a little bit more.
My gut, if you were going to ask the question, is like, what did these people intend, or what did they publicly mean when they ratified these constitutional amendments at these various points? Is
Yeah.
at either period, either at the original founding or the ratification of the 14th, you actually would have had a different problem. I think if you ask people in those eras what they thought of the modern conception of intersectionality, they would have viewed it as a religion. So intersectionality itself would have been a problem, and it wouldn't have been a free exercise problem. It would have been an establishment clause problem. That's my gut on how people in that era would have responded if you told them about modern intersectionality. They would have said, that sounds like a cult.
Yeah, this is a bit why I don't generally spend a lot of time with originalism, is that there's a lot of bone reading going on. Not that I don't think it doesn't have its place. I think that it does have its place at times. I'm not castigating it entirely. It's just, especially in the areas that I practice, I really don't run into it a lot. And so I just, since you guys are interested, at the very least interested or more knowledgeable than me, I just kind of wanted to pick your brains there. Because from my perspective, I feel like the worry around government imposition on the states themselves is a serious concern. And in this case, this is the federal government interjecting into a state government's actions. And so I feel like when I think about originalism, that is something that comes up a lot.
I'll just add as a broader point, right, that I don't want to call, well, okay, I do want to call the conservative justices hypocrites to the extent that they call themselves nonpartisan neutral, right? Because we've been discussing all these levers of originalism that you can pull to get to the result that you want, right? You can you could decide whether the precedent is binding or not. And I disagree with the application of Yoder in this case, right? So you can also modulate, how severe a particular harm is, you think, and how extraordinary a particular remedy is, right? And then if that doesn't get you where you want, then you go back to the original, the historical analysis, right? But then the historical analysis, as we've demonstrated, kind of goes both ways. So then at the end of the day, right, these justices, just like every other Supreme Court justice, has their own personal biases, has their own desired outcomes, and they are ruling to get their own desired outcomes. So I think the court has always been partisan. I think Supreme Court justices have always been partisan. And it's not that we now have these magical originalists who are neutral, nonpartisan, and always going to get the right answer. I mean, I think it's important to acknowledge that in the broader political debate, which we're not getting into here.
So let me respond to that. I've always said that you're right. Originalists, like everybody, are never going to be fully non-biased. I just think the system is less biased. I think the system is, when you actually have a framework as to like law is paleontology, right? Going back to the bone reading quote, which I accept. I don't think that's like a bad thing. I think that when you're talking about something as fundamental as like rule of law, there's a question of like, okay, well, the Constitution sets up law to be changed by XYZ process. You shouldn't be able to get around that. So what does it mean to get around that? Well, I think that if you just like ignore what the law, what the law was meant to mean at the time, in my opinion, the intent of the drafters, really you're getting around the democratic process. You're getting around the legal process for creating laws by using a branch that's not supposed to be doing that. Now, is there going to be situations where the historical record is vague, and you can draw different interpretations, for sure? And is it true that in these areas you're going to see people's biases kind of shine through? Of course. And I think that my goal is never to because it's an impossible goal. It's never to fully eliminate bias. It's to minimize it by establishing some kind of framework like originalism. And the framework of originalism is non-biased.
Yeah, this is, I think, a common, I don't want to say straw man, but I'll say misconception. It reminds me of someone says like, oh, you prefer capitalism. Is that because you think capitalism is perfect? No, I think capitalism is the best alternative of those available. Originalism is not perfect. It does not insulate justices from error or bias. It is simply the best interpretive measure available. And it does the best job of creating consistency and honoring the rule of law, separation of powers, and the enduring Constitution. The alternatives are just less good. And I think that you see this all the time. And if you listen to the justices who espouse originalism talk about it, like you listen to Justice Scalia talk about it, he'll honestly say, there are cases where I go back and I don't have binding precedent. I apply the originalist toolkit and I look to see what did the founders mean when they enacted this clause, and there's no evidence that's compelling. There's nothing there. I don't know. So originalism doesn't work. So I have to do something else. Because originalism isn't a divine mandate. It's just the best possible judicial philosophy. So yeah, I don't think that I'm not threatened by the fact that the justices could make mistakes or have biases. I expect that. I just think originalism is the best way of controlling it.
Okay. I'm going to let you respond to that, but then we are running out of time. I want to respect people's time. And I have one last question that's a little unrelated, but you're all lawyers here, and I'm going to take advantage of that for my one question before we get to close.
No free legal advice. Just saying it now.
Well, you know what? You're getting paid in
We
clout.
represent none of you.
Paid
You are
in
not our
clout.
clients.
Okay.
Fuck off.
So respond, Mike, and then I'll get to my question.
Okay, yeah. I mean, we obviously don't have enough time. I mean, the originalism debate has been made between legal scholars since Justice Scalia founded it. And I do want to point out that it is a relatively new thing, the originalism that we're talking about, because other justices, like Justice Ginsburg, they call themselves originalists too. It's just they use a different level of generality when they're looking at the intent of the framers, right? So again, that's another thing that people modulate to get the result that they want. And I'll readily admit that that's what liberal and progressive justices have done, but that is also what conservative justices do, right? They change the focus of the lens when they're looking at the intent of the history. You know, they zoom out when they need more generality and they zoom in when they need less of it at the end of the day to get the result that they want. And so I think, you know, there's a book that Professor Kamerinsky has wrote, Is Worse Than Nothing, right? When he's talking about the fallacy of originalism, which is sometimes having a faulty legal principle is worse than not having one at all. And we could look at the outcomes. I think we all agree Brown versus Board of Education, not strictly originalist, it's a great outcome, right? Loving v. Virginia, just from an outcome and policy perspective, not a constitutional law perspective. Loving v. Virginia, great outcome, not strictly originalist, because if you were to really be strict about the intent of the framers when the 14th Amendment was drafted, I mean, they did not, you know, interracial marriage was illegal. You know, segregation was going to be a thing for decades moving forward. And I think that's a bullet that Lactoid has bitten. I don't know if Ryan would, but right, a strict originalist would say that Brown v. Board of Education is incorrectly decided on legal grounds. Now, I'm sure Lactoid is not pro-segregation. I mean, maybe he is. I don't know. Not relevant. But I think these outcomes are good things.
Just to be clear, I'm not.
Shots fired.
Okay, I think these outcomes are good things, and they did not come from originalism.
Mike,
right? So I just don't.
I got it, man, because what you're saying is exactly why I'm an originalist. What I do not want judges to do is look at the facts and say, what would be a good outcome? What's best? There's 9 of us. We're all lawyers. We're not Congress. We're not the legislature. We weren't elected. What's best for the country? I'll just decide. I think today that this is what the Constitution says. It is especially that originalism is protecting against. I don't.
It still has to be tethered.
Articulating what's best on policy grounds for the country. That's what Congress does. I want justices to look and say, this is what the law requires. This is what the Constitution mandates. This is what the law. I want them to be lawyers. I want them to apply legal reasoning, not legislatures who ask what's good and noble. I don't want them to look at what's good and noble. It's not their job. The
way you're characterizing this, though, is that the alternative to originalism is just ignoring all of these legal principles, which judges don't do. They still look at the text, they still look at the history, and we've demonstrated here that you can come to opposite conclusions looking at the same history. So it's not like they're like, oh, we'll just forget the history, forget the text, we're not even going to read the First Amendment, right? They read it, they look at precedent, and then they come to a decision on what they think is correct. But at the end of the day, in that final moment, right, when they are modulating and reasonable minds could differ on what the objective reality of history or what was in the minds of the framers, which no one can know for sure, right, that in that wiggle room, people are deciding what they think is correct. And that's just the reality of the Supreme Court. I mean, this is going to be a really long discussion,
yeah,
I think. So we don't have time for it. I apologize.
I might set up another discussion on originalism versus whatever alternative you want at another point.
Living Constitution theory.
Yes, but we'll
and to plug it, it's been on the back burner because of the Karen Reed thing. But at some point a while back, I think Lactoid Recta Law agreed to do an Originalism summit with us. So keep your eyes out. We'll see if he's still game. That would be a lot of fun.
Don't worry, I'll give you all a chance to plug your stuff and give closing arguments in a second. But I did have one last question. It can be very brief, but give me a moment to kind of set the stage here. So recently, after the floods, horrific tragedy in Texas, a streamer you may know, Destiny, said this, and I'm going to quote him. He says, "I heard God killed those kids because they were using @NordVPN promo code Destiny to get around the Texas porn ban." And the reason I'm bringing this up is because NordVPN has took issue with that, and some have said that NordVPN should sue Destiny for unfair use or improper use of their name or what have you. My question, because I don't know the law here, is does NordVPN have a case, or is this clearly a joke, fair use, and they can get banned? Just quick answers would be fine. I'm just very curious.
I mean, this is just my practice area, so I'll just give a really quick answer. The allegation would be trademark infringement, and the analysis in trademark infringement is there a risk of consumer confusion? So, and that's a fact-based analysis. So the question is going to be, if NordVPN sues Destiny, the question is going to be, is a reasonable consumer, so a reasonable consumer, sort of like think of your average consumer who's, of sound mind, right? Reading Destiny's tweet, gonna think that he is sponsored by, endorsed by, or whatever by NordVPN. Now, Destiny's defense, I'm going to guess, is this is obviously a joke. A reasonable consumer would understand it to be a joke, and so no trademark infringement. That's going to be very fact intensive. But that's the question that's going to have to be answered: is would a reasonable consumer think this is legit? Would a reasonable consumer think it's a joke?
I'm piggybacking on what Mike said, which I think was 100% accurate. What makes this case a little tougher for Destiny is that NordVPN's advertising strategy in the online spaces that Destiny occupies is to have influencers like, say, Uncle Roger or someone like
That's
that
what he's mocking, though, right?
Make jokes about NordVPN letting you watch porn from different countries or letting you get around regional restrictions on Netflix, that sort of thing. So it is a joke, but the joke is awfully close to what influencers actually do when advertising for NordVPN. So to the extent that Nord has a case, that they'd probably be litigating that issue.
Any other thoughts from the peanut gallery?
I guess I haven't done like intellectual property law, but I think this should be protected. If I'm just going to go ahead and make a normative claim, like in my perspective, I think the First Amendment obviously would cover what is obviously a joke. I think the point, as many criticisms as I have of the man, the joke is all these influencers will use whatever like moment to glorify like their sponsor. I think that's what the joke is, and I think that it only hits if he framed it the way that he did. I think that's obviously the intent. If IP law starts getting in the way of that, it's fucked.
Okay, Kafka, any thoughts?
I've got 2 points on this. One, considering it was God that told him, I would say that there's an issue that I didn't get to opt out. All right, I have the opt-out right to not hear about his talks with God. I think we can all agree on that here. But I would say that there's another consideration. Mike, correct if I'm wrong. There would also be a consideration around the reasonable person that would engage with it, right? The consumer would not necessarily be a generic one. We could say just Twitter users, right? And so those Twitter users would be familiar with NordVPN endorsements and things like that, and how they're used, when they're deployed, things like that. So that might help him in that people would say, you know what, it's really, you don't see this kind of NordVPN endorsement embedded in a tweet in this specific way. It's usually done in different ways. However, what also cuts against him is that the only people left on Twitter are brain-rotted idiots that'll believe anything they read. And so they probably read that and believed 100% that he was endorsed by NordVPN. So
we all know
it's a toss-up.
He was actually endorsed though by Raid's Shadow Legends.
Yeah.
Yeah, exactly.
I mean, I mean, if you
Oh,
know,
wait, Wick, can't say that.
yeah, careful.
It's a
Gun to my
joke,
head, though.
obviously,
Yeah,
but yeah.
Destiny's gonna lose 100%. So
Oh, fair
that's my
enough.
take.
Okay. Thank you for indulging me on that. I was just very curious because I'd read it and I was like, you know what? I have no idea what the case is here. I have no idea the law here. So I'm going to have lawyers on today. Why not ask them? So I appreciate that. With that, gang, it's been a great show. If you've enjoyed this content, hit that like button. Hit that follow button if you're watching this on Twitch or Kick. Hit that subscribe button. We got some great content coming up. Tomorrow's call-ins. Wednesday, we're going to be having a panel on the BBB, the big bastard of a bill, or the big beautiful bill, whatever you think, right? Is it a net good, a net positive, or a net negative for America? And we're going to have some great people on to discuss that. Non-Fon's going to be there. Vigilante TV is going to be there. Loki's going to be there. It's going to be great. And then on Thursday, me and Tali are going to be talking to Stardust, or Small Talk, I think she calls herself now. I'm not sure. And maybe Short Fat Otaku if we bully him into it enough, about whether or not, or to what extent, the Democrats are responsible for the rise of MAGA. And we're going to have a fun discussion on that. But that said, each of these lovely individuals have given their time of their day to give you content. So when they're giving their closing statements and they're telling you where you can find them, go find them. I have a link to their stuff in my YouTube description. You can find it there. Click that link. You'll go to their Twitter or to their YouTube or whatever they've given me, and you can follow them, subscribe to them, whatever, right? Please do that and reward them for giving us content today. We're going to start with Ryan. We're going to let Kafka have the last word. We're just going to go in order. So Ryan, start us off. Close us out.
Thanks, Wick. And thanks to everyone on the panel. I think it's rare in these spaces that you have like an all-lawyer panel that can kind of get in the weeds on things like we did today. So I appreciate the high level of the discussion and the fact that we were kind of really getting after it a little bit. So appreciate everyone here. Please follow everyone. And please don't think there's any animus, even if we get a little heated at times. Coming up, I am not putting up this recording because I am a Luddite and the recording didn't work. I'll figure out why. That might come next time. But tomorrow,
just to be clear,
I'm going
you can just
on.
use mine, right? If you want to put it on your channel, I'm giving you full access. It's your content too. If you're on my panel, it's your content too. That's my stance. Go ahead.
Love you, brother. Thank you. And tomorrow at, I think like 8 p.m.-ish Eastern time, I'll be jumping on with Sean at Potentially Criminal to talk about other Supreme Court case law. So if you want to see me, waxing philosophical about originalism again, you know where to find me.
Okay, check him out, gang. Lactoid, go ahead.
Yeah, I'm Lactoid. You can find me at Lactoid TV. I just wanted to say that, look, I will support a sort of more originalist interpretation of a law or a constitutional amendment, even if it disagrees with like my basic intuitions or what I like. I think the best example of this is recently the Native American case in Oklahoma, where I think Neil Gorsuch was right, just simply based on his interpretation of the law, despite the fact that I heavily, on a personal level, disagree with the decision. I don't like the fact that Oklahoma's now basically, been subsumed into an ethno state. But this is a situation where I'm just going to be honest. I do think that the majority opinion was correct, but just leaving the law aside for a second, the fact this was even a case, the fact that all parents asked for was, don't please, I don't want my kids to do this. And the school district initially was like, yes, and then too many students didn't want to go because the idea wasn't popular.
I didn't get so bored of Lactoids droning on that I quit. I promise. Okay, it's just we should be back.
Why am I here? I'm fat. I drone on. Wick.
Give
Jesus
it like
Christ.
10 seconds, and the stream should come back on refresh if you're watching this. I don't know. Sorry.
Wick, you're supposed to be a secret conservative. You're supposed to be glossing Lactoid. What's happening, man?
He's sabotaging me.
I have a whole part of my outline where I was going to go after you, Wick, but I see I wasted my time.
Okay, finish up your point, please.
No.
I think Lactoid is done.
Oh, Lactoid's done?
I am done. I do not know where your internet cut out. So
check it out. Lactoid. Check out Lactoid. I did not do that on purpose, King. I'm sorry. We got issues. Okay. And $20 from Alexander Wren to say I sent more super chats, and then my YouTube just fucked out while I was reading this, so I'm losing money too. Damn. So he said, I'm too distracted to pay enough attention to ask a decent question. Sorry, Wick. Don't worry. $20. Thank you for that. I appreciate your money. Mike and then Kafka. Mike, go ahead.
Yeah, you can. I'm not a content creator. I have no desire to be one. But you could find me on Twitter. I just made one recently at Mike2Trees. 2 is a number. I'm grateful for everyone being here, taking the time. These are conversations that I have had, and I would like to continue to have. I have strong opinions about originalism. I do think that I just see a lot of hypocrisy from conservative justices that make me concerned. Sort of about the future of the court, especially because these are life appointments. Just to touch briefly on what Lactoid was saying, just normatively on the outcomes here, I am very sympathetic to the hardships that parents suffer, right? Especially in order to sort of practice their religion, right? This opinion, we didn't talk about this, but this opinion talked about, well, the alternatives are expensive, right? Private school is expensive. Homeschooling is expensive time-wise, and these aren't practical alternatives, right, for these parents. I apologize for the blurry camera. But that seems to only matter to the conservative justices when it's an issue they care about, right? When we're talking about Trump v. Casa, there's no mention of the practical burdens and the costs and the hardships that are going to come from sort of allowing this blatantly unconstitutional executive order to stand. So I just think that's just another example of like plainly partisan rhetoric and plainly partisan rulemaking, right? And so, that's a longer discussion to have in the future. But thanks again, everyone, and I appreciate having the originalist conversation, Ryan. I'm looking forward to doing it in the future, if time permits.
Beautiful. Thank you for being here. Give him a follow, gang. And Republican hypocrisy might be a panel topic coming up in the future, so tune in for that. Next up, last but certainly not least, first time on my channel, hopefully not last, Kafka Esquire. Go ahead.
Hey, I don't really do a lot of content creation either. This is my first ever panel, so I appreciate you guys being really cool. Everybody here, Wick, Ryan, Lactoid, Mike, you guys have been really great to be with, letting me come in here and contend with y'all. I mainly, my biggest thing that I really do online is that I do a weekly executive order report over at the Pragmatic Papers. We're a newsletter that I think I said we focus on misinformation and voter apathy. I just randomly volunteered to say, hey, I'll do like a weekly executive order report, not realizing that we have the executive order in chief right now. He will not stop writing them, so I can never stop writing those reports, unfortunately. But also another great newsletter I'd like to shout out. It's called BNN. Really good guys over there. They write good stuff. I don't get to have a lot of these kind of conversations in my area of work. It's just these kind of topics just don't really come up. So it's a really great place to come and just hear some good ideas. Mike, I really appreciate you being my partner on this one. You just did a great job on this, and I hope I didn't weigh you down too much. Lactoid and Ryan.
Not at all.
Thanks. Lactoid and Ryan, it was super fun to contend with y'all, especially when it gets heated. That's always the funnest kind of conversations. So I'm with y'all. I'd be super happy to do another one with you guys anytime. If you guys ever want to find me, honestly, the best place to do is just go over to the Discord or go to Destiny's chat. I'm usually hanging around one of those places different parts of the day. So the last statement just about this case, as I said at the beginning, I'm a father and I am sympathetic to concerns about what's being taught at school, but I think that those concerns in this specific case are best addressed at home. I think that whenever I think about the religious upbringing of my own child, things like that, I welcome challenges and difficult conversations about my religion. This is not a rights thing of the Constitution, just a perspective from a father who believes in a religion of I don't shy away from these things. I'm not afraid of them. And I think that if you have true religious conviction, you should welcome them and be willing to address them, even with a small child. And yeah, Wick, also, I didn't say it to you. Thank you. I appreciate you letting me come in here and also not turn my camera on. I'm sorry, everybody, about how little self-esteem I have that I need to hide behind this cute avatar. But like I said at the beginning, right now, I'm just not giving out any kind of personal information if I can help it.
Makes sense. Gang, check him out. I have a link to his Twitter, at least, in the YouTube description. Go find him and go check out those other places you mentioned. We're going to raid into Lactoid TV, and he can do whatever. So, bye-bye, everyone. Bye.
Bye-bye.
Bye, friends.